Good morning, Your Honor. Brian Kipnis, Assistant United States Attorney for the government.
Sarah Bishop, Assistant United States Attorney for the government.
All right, good morning, everyone. We are here this morning on two motions, a motion to clarify the court's prior injunction in the 25-1228 matter, and a motion for a temporary restraining order in the new companion case 26-2409. Since there are two motions pending, I think it makes the most sense to start with the government's motion to clarify. It was filed first, and it sort of frames the issues anchoring us in the prior case. So let's go ahead and do that. I will give both sides a chance to respond to each other, though, and attempt to be efficient as we work through these issues. So, counsel?
Thank you, Your Honor. The court should grant the department's motion to clarify the permanent injunction in Washington 1, which I think is what we'll be calling it, and hold that nothing in the court's injunction or judgment precludes the department from terminating any grant under separate regulatory authority, that regulatory authority being Title II Code of Federal Regulations, Section 200.340.
What subsection is the government proceeding under?
Your Honor, I don't know which precise subsection they'll be terminating under. They've only informed me that the terminations will occur under that authority.
Presumably, it would have to be A4, though, right?
I can't answer that, Your Honor.
All right, go ahead.
I don't have that information.
I will be curious, and I'm hoping you'll explain to me how the court can clarify whether the government's intended action violates the injunction without knowing the basis for the action.
I'll try and answer that question at this point, Your Honor.
Thank you.
So the terminations are under an entirely separate regulatory authority from that under consideration by the court in this case. The only issue before the court in this case had to do with non-continuation decisions. Non-continuation decisions are made under 34 Code of Federal Regulations, Section 75.253, subsection A. The court construed that regulation. It enjoined the department from applying that regulation in a manner that the court found to be unlawful. It also ordered the department to not apply to non-continuation decisions or continuation decisions a directive procedure that had been internally published by the department in April of 2025. The department complied with the court's injunction. It issued new continuation decisions in January, and all of the grantees that were subject to that judgment received new decisions and are continuing in their grants under that particular regulation in the court's injunction. The court, nothing in the prior, in Washington 1, had anything to do with terminations. In fact, the plaintiffs very much eschewed any contention that that was under review were terminations, which they represented to the court and to the Ninth Circuit, was a materially different type of procedure, and consequently not subject to the exclusive jurisdiction of the U.S. Court of Federal Claims by reason of the Tucker Act. And so the court, I think, mindful of those constraints, those jurisdictional constraints, issued an injunction that was within those parameters. So the point being, Your Honor, is that the reason for the terminations, the specific subsection or how they're arrived at, which at this point, Your Honor, we don't know because there has been no terminations. It's only a plan at this point. They've informed the court of what their intentions are. But the precise reasons, the precise basis for any of those terminations is something that we don't know, but in any event has nothing to do with Washington 1. And indeed, because of the Tucker Act, the precise legality of those terminations is not subject to adjudication under the APA in this court.
And is that why the government didn't defend the legality of those terminations in its
Certainly,
response?
certainly, Your Honor, We did not want to be litigating an issue in Washington 1 that we did not think was within the jurisdiction of this court to adjudicate.
And what's your best authority for the proposition that a planned or future termination is outside this court's jurisdiction under the Tucker Act? Because the authority cited in in the briefs has to do with terminations that have already been accomplished where reinstatement was ordered.
Your Honor, our primary authority on that would be the recent decision of the Ninth Circuit in the Thakur case. In Thakur, the preliminary injunction issued by the court was one that had both effect on terminations that had occurred and prospective terminations that were going to occur. The Ninth Circuit determined that that preliminary injunction was foreclosed by the Tucker Act, and it reversed the district court, both as to the aspect of the injunction that was prospective and retrospective. So our authority is basically Thakur. Thakur has basically held that an injunction of that nature that would enjoin prospective terminations would be beyond the jurisdiction of this court.
So what do I do with Justice Barrett's concurrence in NIH that identifies the space for the district court that remains under the APA with respect to a policy accompanying an action affecting a grant?
So, Your Honor, we could definitely see an argument under the NIH case that the court could proceed and retain jurisdiction to determine the legality of a guidance document under an APA analysis. However, the flip side of that coin is the court still would not have jurisdiction to enjoin a termination, that those would be, as Justice Barrett indicated, those would go down separate tracks, and while the court could review a review procedure under the APA for arbitrary and capriciousness, it could not enjoin a termination.
All right, go ahead, counsel. I took you off track here.
Well, it's sort of like, and I think it's inevitable, it's sort of folded into the argument we would make in opposition to the TRO, but well, we recognize also, Your Honor, that the court also enjoined the department from implementing or enforcing through any means the directive procedure, the discontinuation notices, or reconsideration denial letters, but that is not what is occurring here. The department is not making unlawful continuation decisions by other means. It is simply terminating the grants under separate regulatory authority. And contrary to the state's evidence-free allegation, the department is simply applying the February directive procedure to affect these terminations. The department has placed into the record the declaration of Murray Bissett, evidencing that the department is not applying the directive procedure. To the contrary, Mr. Bissett testifies that the department's terminations will be made on an individualized basis without relying on that guidance document. The states have produced no contrary evidence. Instead, they take the wording of the court's order out of context and argue all evidence to the contrary, that the court's intention in writing its injunction was to extend its jurisdiction beyond Tucker Act limitations. And the claims actually adjudicated in the case in order to prevent the department from ever terminating the grant agreements before their expiration. Clearly, we do not believe that was the court's intention, and in any event, as established by Ninth Circuit precedent, that would in effect be an improper expansion of the court's jurisdiction beyond statutory limitations through an injunction. We submit, Your Honor, that the department's motion to clarify should be granted, and it should have the relief it requested.
Mr. Kivnis, before you step down, so
Sure.
you said that the plaintiffs did not provide any evidence of a new directive, and you combined that, or you contrasted that to the Bissett Declaration. But the government didn't provide the June 2025 directive in its certified administrative record in the Washington 1 action.
That's-
And that's troubling. Do you have any reason to know why that was excluded?
Yes, because it played no role in any decision-making in that case, so it was not part of the administrative record. The terminations occurred before June themselves. Plaintiffs alleged that the June directive was considered as part of the reconsideration process. It was not. I've clarified that with the department. They assure me that they felt, and I think correctly so, that it would be improper to apply the June directive, and so they didn't apply it. And so because they didn't apply it, it's not part of the decision-making process. It's not included in the administrative record.
And what do you make of the fact that the February directive discusses terminations?
What do I make of it? Again, the February directive has not been effective for some time now. It did not play a role in these terminations.
And it's the government's position that the June directive was not used in denying reconsideration. I just want to make sure I understand
Correct.
that.
I have been specifically informed that by the department, so I'm representing that to you, Your Honor.
All right, thank you. All right, let me hear from the plaintiffs on the clarification issue.
Good morning, Your Honor. Jennifer Chung, here on behalf of plaintiffs. Plaintiffs are seeking two things today. First, we'd like an order clarifying that the permanent injunction prohibits defendants from terminating a grant using defendants' new priorities which haven't gone through notice and comment rulemaking. And second, we also seek a TRO that enjoins defendants from implementing the directives or the Washington Plan as to protected grants. I'll address the request for clarification. Ms. Range will address the TRO and discuss the relationship between these two requested orders in more detail. Before I begin, I'd like to remind the court how we got here. For the past 15 months, defendants have used any means they can to stop funding grants that are providing critical mental health services to kids within plaintiff states. After the court granted a permanent injunction in December, grantees thought they could move on and return their focus to providing mental health services to kids, not this lawsuit. Instead, for the past 7 months, defendants have continued to fight tooth and nail to stop funding our grants. Defendants' efforts to make life miserable for our grantees has been extensively documented in our briefing on the two motions to enforce. And we see a pattern here. Defendants say that they'll make a continuation decision by the end of last year, but then they missed the deadline. Defendants said they'd issue 1-year continuation awards, then they only provided 6 months of funding. Defendants said they'd make funding decisions for the second half of 2026 after mid-year check-ins. Well, they made our grantees go through those check-ins, but now they're asking for the court's blessing to terminate these grants. Defendants are trying to wear our grantees down, and unfortunately, these tactics are working. Every time defendants file a new status report, they announce that another grantee or another group of grantees has voluntarily terminated their grant. And each grant we lose is a grant that is no longer funding critical mental health services in our public schools, which harms our kids, our schools, our staff, our graduate students, our future mental health workforce, and our state Medicaid and educational systems. Now, apparently, defendants' grant attrition strategy is too slow, so now they want to terminate some or all of the grants beginning on July 31st. And this is what in the TRO we refer to as the Washington Plan. And we see the Washington Plan as having two main components. The first is very straightforward. They're applying the enjoined directive procedure to terminate rather than discontinue protected grants based on defendants' new priorities that have not gone through notice and comment rulemaking as GEPA requires. Second, they're unlawfully terminating grants by immediately terminating them without complying with procedural protections required by GEPA and federal civil rights statutes such as Title VI and Title IX. Now, plaintiffs believe both parts of this plan could violate the permanent injunction, but recognize the court may be reluctant to address the second part as it does require going into the meaning of specific statutes and regulations that haven't come up here. But in order to ensure maximum protection for our grantees, our schools, and our kids, we're requesting a clarification that termination based on the unpublished priorities would violate the permanent injunction, and also a TRO that would stop defendants from carrying out the second part of the Washington Plan. And Ms. Range, again, will discuss the Washington Plan in more detail when she addresses the TRO motion. So defendants would like a clarification order that says termination of a grant agreement pursuant to 2 CFR 200.340 would not violate the court's December 19, 2025 injunction. The court should not enter this clarification because it's wrong. Instead, the court should enter an order that clarifies that terminating a grant using defendants' new priorities that have not gone through notice and comment rulemaking would violate the injunction. And I'll provide 2 reasons. First, the June directive that defendants attached to their reply brief is quite literally the enjoined directive procedure. And second, the injunction applies to any means of implementing the directive procedure and doesn't have a carve-out for grant termination. Now, Your Honor's injunction enjoins defendants from implementing or enforcing through any means the directive procedure. This enjoins the substance of the directive procedure, not the piece of paper it's written on. And defendants say in the reply brief they have a concrete plan, and they attach the June directive. The June directive is quite literally the directive procedure which was enjoined because it directed staff to use new priorities to re-review grants and did not run those priorities through notice and comment rulemaking. So the directive procedure starts with the February directive, which, as this court explained, ordered an across-the-board re-review of department grants and measured them against new criteria. Although the February directive directed staff to terminate grants under 2 CFR 200.340A4, defendants instead applied those new criteria to discontinue grants using the best interest determination under 34 CFR 75-253A5. So that's the directive procedure, applying the February directive to discontinue rather than terminate grants based on unpublished priorities. And although defendants claim that they didn't use the June directive as part of the reconsideration denials, that contradicts their own testimony that also says the February directive was not used to review any grant after June 2025. And it's really interesting that the June directive instructs defendant staff to look at the grant applications when making this determination about whether or not the grant should be discontinued. And funny enough, the reconsideration denial letters all use quotes about equity from the grant applications to justify their conclusion that the grants should be discontinued. Now, defendants have attached, for the first time, the June directive, and this is what the defendants cite in the reply brief when they say the department will not be applying the directive procedure. And we heard it again just now from Mr. Kipnis, that when they say the directive procedure, they are literally interpreting that to be solely the February directive. The June directive actually appears to memorialize the directive procedure used for the original discontinuation decisions and based on defendants' new testimony would have been the procedure in use when considering grantees' reconsideration requests. The June directive applies the February directive review procedure and directs staff to discontinue rather than terminate grants. Again, the exact procedure that was enjoined. Both directives share the same unpublished priorities of merit, fairness, and excellence in education. Both directives direct program staff to end funding for grants that are supposedly inconsistent with these priorities because the grants appear to support diversity, equity, and inclusion. And the June directive contains the exact same lengthy disjunctive list that the April non-continuation letters and the August and September reconsideration denials use as justification for ending the grant funding. Of course, if defendants had produced the June directive in the administrative record, plaintiffs would have asked the court to enjoin it by name. Instead, defendants produced it for the first time a few weeks ago for the sole purpose of claiming they're not using the February directive. They're using a different piece of paper. But what matters is the substance, not the form. And this is like what the Ninth Circuit said in the second citation case. No injunction can explicitly prohibit every conceivable plan designed to defeat it. Defendants have entered the June directive into evidence, and it shows that defendants' concrete plan is to terminate grants using the unpublished criteria in the February and June directives, which have not gone through notice and comment rulemaking as required by GEPA. If defendants proceed with this plan to re-review and terminate protected grants, they will violate the permanent injunction. And I would like to address the injunction language itself. Grant terminations are within the scope of the injunction for 3 reasons. First, this court enjoined the directive procedure regardless of the means defendants used to implement it. This court expressly decoupled the directive procedure from the continuation regulation that was subject of other claims. The directive procedure, however, was unlawful because, among other things, defendants did not comply with GEPA's notice and comment rulemaking requirements before applying the directive and its new unpublished priorities. This court specifically said it was of no consequence that defendants engaged in this process under the guise of the 34 CFR 75253A5 best interest determination, and the Ninth Circuit agreed in its order denying defendants' second emergency motion for stay. The Ninth Circuit said defendants' actions were likely unlawful even under defendants' broad interpretation of the continuation regulation's best interest provision. Again, this is because defendants were required to engage in statutory notice and comment rulemaking requirements before using their new priorities. They simply cannot use regulations to override statutory requirements. Now, the second reason is the language of the injunction, where it enjoins defendants from implementing or enforcing through any means the directive procedure. Any means means any means. There's no exception for terminations. And the injunction even provides an example of recompeting grant funds, which shows that any means is much broader than a non-continuation based on the 75253A5 best interest determination that was the subject of the litigation. And third, as Your Honor pointed out, is the February directive itself. The source of the directive procedure expressly directs department staff to terminate grants under 200-340A4. Clearly, defendants contemplated that termination was a means of implementing the directive procedure. Defendants are apparently trying to read in an implied exception to this injunction, that termination can't be a means of implementing or enforcing the directive procedure because of the Tucker Act. This is based on defendants' claim that challenges to grant terminations fall within the exclusive jurisdiction of the Court of Federal Claims. As Your Honor pointed out, this appears to be a patently false statement under NIH, and as Ms. Range will discuss in greater detail in addressing the Tucker Act in the context of the TRO, we have procedural protections by statute that specifically allow an administrative hearing and judicial review for terminations of GEPA-covered grants. But here, it doesn't matter what regulation defendants use to implement the directive procedure. Regardless of whether it's the continuation regulation or the termination regulation, defendants have a statutory requirement to engage in notice and comment rulemaking under GEPA. If they don't go through the rulemaking, they can't use their new priorities to make funding decisions that affect grants. The court didn't need to interpret the continuation regulation to know that the directive procedure was unlawful. The court doesn't need to interpret the termination regulation here. The court definitely doesn't need to interpret any terms or conditions of any grant agreement to make that conclusion. Defendants keep trying to use the Tucker Act as a get-out-of-jail-free card, which it is not, and they can't use it here to escape the court's permanent injunction. I'll pause here to see if Your Honor has any questions before I conclude.
So what do you make of the government's argument that the plaintiffs, in the context of the motion for clarification, did not cross-move and are seeking affirmative relief, which also seeks to clarify, or they would say expand, the court's permanent injunction?
Your Honor, we don't see this as an expansion or a modification of the injunction. We simply see this as a dispute about what clarification, which defendants asked for, should actually be issued by the court.
So are you agreeing that the injunction needs clarification in some manner?
We believe that defendants' behavior shows that they plan to terminate the grants and to use any excuse they can to terminate them. Now, Ms. Range will discuss the relationship between the relief sought in the TRO and the clarification here. But it seems to us that if the court simply denies defendants' clarification because it's not concrete, then defendants will say, oh, the injunction doesn't say either way, clearly we can proceed, which is why we need the TRO.
All right, thank you, counsel. Mr. Kipnis, do you wish to respond now, or would you like to wait? I'll give you a chance to respond both times. I just don't know how many times you want to get up.
Yeah, I think it makes more sense to respond in the context of.
All right.
All right, Your Honor, and then I'll turn it over to Ms. Range.
All right, thank you, Ms. Chung. Ms. Range?
Good morning, Your Honor. I'm Ellen Range here on behalf of the plaintiff states. Once again, defendants are disregarding the laws so they can end funding for grants that they've tagged as supporting DEI. They cannot defend the lawfulness of the directives or the Washington plan, so they attack this court's jurisdiction. But we are not here to contest grant terminations or to get them reinstated. We are here to prevent the implementation of a plan that is plainly illegal. Defendants cannot terminate based on new priorities, and they cannot terminate effective immediately. To do so would violate the change in position doctrine, the termination regulation, GEPA rulemaking requirements, GEPA procedural requirements, civil rights procedural protections, and the spending clause.
I don't hear the government to have disputed any of that, and query whether those arguments are waived. But what their only argument is that because the government has said terminations, this court loses jurisdiction. What's plaintiff's position on that?
That's incorrect, Your Honor, and squarely contradicts Justice Barrett's concurrence in NIH. The court held that challenges to agency guidance, even those informing grant terminations, belong in district court. And when pressed about, well, what case do you have to support this proposition, the defendants provided the case of Thakur. And when we looked it up, what the injunction that they're referring to, what that order said was that they were vacating future grant terminations. And so they were attacking future grant terminations as opposed to a policy that, when implemented, as the result, becomes grant terminations. And so the order in the Thakur case, what that did was it would reinstate future terminated grants. That is not what we're asking for here, Your Honor. That is not the order that is before this court.
Is that the difference then? The dividing line, is the difference a order of reinstatement? Because, I mean, we have the precedent that we have, but in the real world, it's hard to draw a line between a policy and the impact of that policy. So what's the line that plaintiffs are advocating for under the post-Thakur NIH world?
Yes, and I think that's in part what Justice Barrett was wrestling with, Your Honor. But I think what the Supreme Court was really fixated on, because they didn't really apply the megapulse test, what they were fixated on was what does the order say? And if the order was reinstating grants and effectively requiring the government to continue to pay money, that to them was money damages, and so therefore that could only be ordered by the Court of Federal Claims. We don't have that here. We don't have that type of order. Instead, as defendants concede in their own briefing, they themselves say plaintiffs now seek an order preventing defendants from terminating the grants. We're in that prevention, prospective relief posture, Your Honor, that NIH found the district court can retain jurisdiction over, and the Ninth Circuit. That was the Ninth Circuit's holding for our case in Washington versus the Department of Education, where it said where plaintiffs are seeking prospective relief, the district court retains jurisdiction. And so I would like to just briefly address the final agency, or sorry, the relationship between the two motions, so we're clear here, Your Honor. If Your Honor grants defendant's motion and holds that the injunction allows for terminations, then we would need immediately a temporary restraining order. But I did want to take a moment to explain why, even if Your Honor denies defendant's motion for clarification and provides our requested clarification, plaintiffs would still need a temporary restraining order. And that's because the clarification as requested by plaintiffs protects grantees from only one part of the Washington Plan, that is the unlawful use of unpublished priorities to terminate, but we have a temporary restraining order to protect grantees we would need a temporary restraining order to protect grantees from the other part of the Washington Plan, and that is defendants' plan to terminate grantees in violation of GEPA procedural protections, as well as their own regulation at 3475-903. That this threat is imminent is plain from their representations in this case, where they have said that they're going to begin terminating on July 31st, and that they said that they only filed their motion for clarification in an abundance of caution, meaning they don't think that they actually needed to. The threat is also plain from their actions in other cases where again and again defendants have terminated Department of Education GEPA grants effective immediately, which contravenes the GEPA procedural protections. And we provided illustrations of that, Your Honor, in our complaint at paragraphs 86 through 93. And in the Council for Opportunity in Education case, defendants did not seek permission from the court before terminating the grants, even though there was an injunction in place. The threat is also plain from their representations today here in this court, Your Honor. You asked them, tell us, what is the basis that you're going to use? Is it A1 or A4? And they cannot say. And I submit, Your Honor, that the reason why they cannot say is because instead of offering assurances of, oh yes, we're going to use A1 and A4 or just A4, is because they don't want to be pinned down and told that they cannot do that. With that in mind, Your Honor, we would ask that you rule from the bench and issue a minute order granting a restraining order so we can be protected as we proceed. And I would like to address as well the final agency actions that are at issue in this case. That is the February directive, the June directive, and the Washington plan, which the February directive, as Ms. Chung described, lays out new priorities and instructs staff to terminate under the A4 termination subsection. And that would be effective immediately under the other regulation that they cite to in that February directive, which was 2 CFR 200-341, without GEPA procedural protections. And then in this June directive, it incorporates the very same priorities that were listed out in the February directive and instructs department staff to make funding decisions based on GEPA equity statements. This Washington plan begins terminations on July 31st. It's effective immediately and depriving grantees of GEPA procedural protections as a result. And the evidence of that, Your Honor, is when they describe in their motion for clarification, they say that grantees will continue to have funding available until the department issues a notice of termination. And that immediate cutoff means that GEPA procedural protections are not happening. They also told grantees that they have to contest these terminations in the Court of Federal Claims. Well, you don't have to do that if you have GEPA procedural protections. You go to the administrative law judges. And so all three of these actions satisfy the two prongs of the Bennett test. That is that they mark the consummation of agency decision-making and have legal consequences. The directives provide guidance to department staff on how to evaluate grants, and because they affect funding decisions resulting in some or all of our grantees getting terminated, they have clear legal consequence.
Ms. Range, let me pause you there for a moment. So the parties had asked for a decision in advance of July 30th. Help me understand, has something changed? You just asked for a minute order entering relief today. Why do the plaintiffs need relief today? This was originally noted as a PI.
Yes, Your Honor. And what has happened is that we saw the June 30th notices, and we have been looking at their actions and in consideration of their actions in this own case, where it's somewhat of a surprise that they haven't shown up today to say that all these grants have been already terminated and this case is moot. And so the fact that they have this practice of proceeding anyways, and they themselves have not offered this court assurances that they're not going to do that, is the very reason why we need this TRO today.
Well, I think they have stated that terminations would happen no earlier than July 31st, haven't they? I agree, the record on candor is not great.
Yeah, and so we just, because of this concern that we have about, especially because they've been arguing even to the Court of Appeals that the appeal itself might be moot because all of these grants would be terminated, we just have a very real concern that our grantees are in danger today. And we just have we can take no comfort in any representations that they make that aren't stipulated to, right? So if they offered assurances, yes, Your Honor, we will stipulate and we will not terminate these grantees before July 31st, then yes, we could feel comfortable in not getting a TRO today. But because we cannot get assurances along those lines, we also can't even get assurances as to which basis they're going to use. That is the reason why we need this TRO, because our motion for clarification only covers one part of the Washington plan, and it exposes us to the unlawful conduct of defendants in their quest to terminate these grants and in the process violate the procedural protections that we've described. As Your Honor pointed out, they have left the merits of our claims unaddressed, so we are planning to rest on our papers for our contrary to law, arbitrary and capricious, and spending clause claims. Should this court enter a temporary restraining order just based on a few claims, then it may apply precedent from our discontinuation case and hold that defendants likely acted arbitrarily and capriciously. The Ninth Circuit has already held that the department acts arbitrarily and capriciously when it deviates from its grant-making guidance without acknowledging or explaining the change in policy, and that is again what has happened here. Defendants are terminating immediately without offering an opportunity to come into compliance. This is a complete 180 from the discretionary grant-making guidance that promised ongoing support because they are the administrator of financial assistance programs. And in that role, it is their role to help these grantees succeed. So if the grantees are having a hard time with reaching the goals of the grant, then what defendants represented in this guidance was that they would help the grantees get back on track before resorting to termination. And that's clear, Your Honor, in the Chung Declaration, Exhibit B at page 48, as well as Exhibit A at page 38. As I've been saying, Your Honor, defendants also cannot terminate immediately without violating GEPA procedural protections. And by directing the plan terminations take effect immediately, the Washington plan seeks to terminate protected grants earlier than permitted by law. They have to first offer notice and a hearing before terminating. That's under 20 USC 1234D. And also under their own regulations, it says that terminations are not effective until a final decision is reached through this administrative process. And that's at 34 CFR 75. 903 subsection C. So turning to the equities, Your Honor. For the remaining winter factors, Your Honor has already held that the balance of equities in the public interest favor plaintiffs, and you may do so again. Defendants conceded plaintiffs' irreparable harms, and they have failed to show their own. They try to stand in the shoes of government agencies that had already terminated grants and would be forced to reinstate them, but that is not the case here. And because the temporary restraining order would not require payment, it is unclear how they can claim this harm as well as the need for a bond. With that, Your Honor, I'll conclude unless you have further questions.
All right, thank you, Ms. Range. I'll give you an opportunity to follow up after we hear from Mr. Kipnis.
All right.
Mr. Kipnis, what's your response to the plaintiff's concerns that relief is needed today? Is the department willing to stipulate that those representations regarding the terminations no earlier than January 31st?
That is what we represented to the court. I have no reason to believe that there's no reason to believe that the department isn't going to stand by its representation there. None. I think that Your Honor, we specifically brought this motion the way we did so that the court would have the opportunity to adjudicate this, to have the briefing of the parties, to, with its law clerks, to decide what its ruling should be. And we specifically said it for July 31st. There's no reason to believe that we're going to go back on our word there. That's just ridiculous.
All right, I appreciate that, and I'll accept that, Mr. Kipnis. Thank you. Does the department intend, what's the response with respect to the GEPA procedural protections? Because I noticed in the Bassett Declaration, it stated that the terminations would be something to the effect of completed with, the procedural protections in place. I'm not getting the exact words correct. But does the department intend to go through the GEPA procedural protections, or will the terminations be a cutoff, an immediate cutoff, as the letter sort of suggests?
I think that, I know you want a direct answer, Your Honor, but I don't think I can answer that one directly. So let me just answer it this way. First of all, there's an assumption here, right, that the GEPA procedural protections apply. And that requires an assumption to be made about the basis for any single termination. We don't know what that is.
Is there a reason that GEPA, I thought we were pretty much all in agreement that GEPA applies to these grants. So it was certainly not contested in Washington 1. Is there some reason to think that it doesn't?
I mean, under certain circumstances, depending on the grounds of the termination, possibly, but not simply because they're terminating the grants. There's no requirement that every time a government agency terminates a grant that they have to promulgate a regulation through notice and comment rulemaking to explain and justify the reasons that they're terminating that grant.
Oh, no, I'm sorry. Maybe I wasn't clear in my question. I was referring to the GEPA regulations that pertain to grant terminations under the statute specifically. I thought I understood Ms. Range to be saying that grantees before termination under GEPA and under the department's regulations would be entitled to an administrative hearing, which would then be subject to judicial review before termination.
I'm not an expert on GEPA, but my understanding is that it depends on the grounds for the termination, that doesn't apply to all terminations. Maybe Ms. Range knows differently than I do, but I don't. I don't know that to be true. So my first contention, your argument is there's an assumption there that GEPA applies. I don't know that to be true. To answer your second question, I mean, I have to, first of all, there's an assumption on my part that the government is going to follow the law. I don't know any differently, but our point would be even if the government doesn't follow the law here, and the contention is it's inevitably going to be that the government isn't following the law. We get that. But that's an issue for the Court of Federal Claims. It's not an issue for this court.
Is that correct, though? I mean, if the argument was, and I understand that the government's position is that anything relating to a termination should be in the Court of Federal Claims, but if the argument was that a grant was terminated in violation of a statute and the relief requested is the plaintiff's procedural rights under the statute, is it the government's position that's also a Court of Federal Claims issue?
Yes, because the grant termination would be unlawful and the plaintiffs would be entitled to the remedies afforded to them by the Court of Federal Claims. That is the way the system works.
Even though the Court of Federal Claims can only give contractual remedies,
Correct.
and the remedy they're seeking would be procedural and statutory.
Correct.
Does the Court of Federal Claims have authority to order that?
Does the Court of Federal Claims have the authority to order what exactly?
To order that the department provide the due process protections required by GEPA?
No, I do not believe they do. Again, not a claims court expert, but I do not believe they have any equity authority whatsoever. It's simply a remedy that would, for the unlawful termination of the agreement. But the system is set up such that district courts do not have authority to intercede in that process, that the government gets to terminate grants, the jurisdiction to adjudicate the legality or lack thereof is within the Court of Federal Claims, and to afford an appropriate remedy within the jurisdiction of the Court of Federal Claims.
So is it the government's position then that the GEPA procedural protections and right of action thereunder is unenforceable?
It may be enforceable a different way, Your Honor. I don't think that it leads to the court's jurisdiction to interfere with the termination of the agreement. But if you follow the second, the concurrence, Justice Barrett's concurrence, then the court has an ability to adjudicate it on a separate track.
And if this track was filed first, wouldn't that track go first?
No.
And why is that? What's the authority for that?
Again, we're going to rely on Thakur. Okay, basically, in Thakur, the argument was essentially the same that the states are making here, and the court basically issued an injunction in accordance with that argument. It said, in addition, plaintiffs have shown a significant likelihood of future unlawful terminations to the certified classes pursuant to the same policies at issue. And then it said, accordingly, the court will order on a prospective basis that future grant terminations meeting the required criteria are likewise vacated upon issuance and may not be given effect. So basically what the court did was, following an argument similar to what the states are making here, is to basically say, yes, we're going to enjoin future grant terminations. And that is what the Ninth Circuit reversed in Thakur, that preliminary injunction.
I have a question about the termination regulation. 2 CFR 200-340 Part B requires that the agency must clearly and unambiguously specify all termination provisions in the terms and conditions of the federal award. Do the grants here contain the basis for termination that the department intends to pursue, or anything about the termination procedure?
Since we don't know the basis for the termination, since the terminations haven't occurred, and we don't know the basis for the terminations will be in a written decision that is given to the individual grantees. We won't know the basis for the termination of any specific grant until that termination occurs, which it is not yet. So not only is the argument not right, but there's no final agency action. To argue that there's a final agency action here when no termination has occurred, the very basis, by the way, of APA jurisdiction is a final agency action. We don't have that here, so there's no basis for the court to intercede under the APA. In the absence of a final agency action, there's no, the APA jurisdiction, even if you're going to apply the APA, hasn't even arisen here yet.
But there is a sufficiently concrete plan to provide letters to the grantees and to seek clarification, which again, I appreciate. But help me deal with the tension between there's enough of a plan to send out termination letters, to come into court and say, we're planning to terminate the grants, here's the termination regulation, but there's not final agency action. Isn't this kind of a
The
catch-22?
so-called Washington plan doesn't exist, okay? Basically, what the plaintiffs are calling a Washington plan is simply our coming forward to the court in good faith and telling the court that some or all of these grants are terminated, are going to be terminated. That's what the department is proposing to do, and to seek clarification that that does not violate the court's injunction in Washington 1. That, I guess, is the Washington plan. That is a far cry from anything that resembles a final agency action. That's simply coming to the court and informing the court of what the department intends to do.
Help me understand, there's been a lot of discussion about the June 2025 directive. What's the government's view of what that is? I understand you said it wasn't used in Washington 1. What's its role in this case, if any?
None.
What was it used for? Why is it attached to the Bissett Declaration?
It was attached to the Bissett Declaration because it was an attachment to another declaration that they filed in another case. And so they gave you the complete declaration. But it has played no role in this case. And it will not. And again, the decisions will be made on an individualized basis, not on the basis of a directive procedure of any kind, not on the basis of the June, the quote, I guess we're calling it the June directive, not on the basis of the February directive, not on the basis of any directive. They are simply going to decide on the basis of the merits of the individual grant.
The merits of the individual grant as compared to what?
As compared to what they believe the merits to be. It's a policy decision, Your Honor.
Right, I understand that. I mean, of course it is, it's an agency. But we have a policy decision with no policy?
The decision is going to be made on an individual basis, Your Honor. The basis for the terminations is unknown to me. The decisions haven't been made yet.
But the agency anticipates making them next week, before Friday.
Yes. Well, not before Friday. I think that's what we told the court.
Right. But the letter suggests they could be made Friday and be effective immediately.
That could occur. I don't think that's going to occur, but that could occur. Certainly under what we inform the court, that's not an impossibility.
All right. All right, thank you, Mr. Kipnis. Ms. Rain?
So we do believe the state's application for a TRO should be denied for two reasons. As we've argued, and I don't want to beat the dead horse at this point, but we do not believe the court has the jurisdiction to either adjudicate the legality of or enjoin the grant terminations. Secondly, plaintiffs have put forward no evidence that there's anything unlawful about the proposed grant terminations. Rather than putting forth any evidence, they simply hypothesize that the terminations will be illegal and ask for relief on that basis.
Let me pause you there just for
Sure.
one moment. What evidence beyond what the department has provided could the plaintiffs put forward? What is the government suggesting that plaintiffs are lacking? Because what we've heard so far, the government has all the documents. The government has an unstated reason for an anticipated termination on a policy that's not been articulated to anyone. What should the plaintiffs put forward in order to make their case?
I mean, if the court had jurisdiction, they could put the terminations themselves before the court. And I assume that if this case goes on, that's what they're going to attempt to do. But, yeah, be the terminations themselves. And the written decisions that accompany those.
All right, go ahead.
Okay. We've talked a lot about National Institutes of Health. We talked about Thakur versus Trump. I don't think I need to go through those, Your Honor. They're very familiar with those cases. We've talked about them a number of times here. In an effort to avoid these holdings, the states argue that the rule in NIH and Thakur only apply after the terminations occur. However, as we've kind of laid out in Thakur, the relief in that case was issued not only on a retrospective basis, but a prospective basis. The Ninth Circuit reversed that preliminary injunction, saying the court was without jurisdiction to issue that preliminary injunction. That holding is controlling here. We'd also kind of should note, with respect to NIH, 8 of the 9 justices said that you can't meaningfully split a termination from the a review of the policy guidance. And so Thakur sort of joins those two things and basically says no jurisdiction. And so that, we believe, is what binds the court here. We'd also note, we touched on this already, that before the terminations occur, the claims under the APA are simply not ripe. There's also no final agency action here yet until the terminations occur, which are themselves the final agency action, so there's no APA jurisdiction even under conventional APA law. We also think, as we said before, that the states are reading the cases incorrectly and that based on Thakur, a prospective injunction is just as invalid as a retrospective one. Turning to the evidentiary question, the state's motion asks the court to issue a TRO without putting forth any evidence that the department's contemplated termination of any single grant will be unlawful. They simply allege without evidence that the department's termination will be based on unlawful guidance documents. There's no evidence to support that. There's evidence to the contrary. That should be controlling for the court. So the motion may be denied on that basis also. The basis of the TRO motion is simply speculation that the department will act unlawfully. There's no evidence before the court that supports that. The court can't issue a TRO with an absence of evidence. And that is what we have here, an absence of evidence. The department will do anything unlawful. There's really no evidence, no declaration, no support whatsoever for the state's arguments here that they will substantially prevail on the merits. They haven't shown anything, Your Honor, in support of that. A party seeking a temporary restraining order can't prevail when the motion is unsupported by evidence. Evidence is required here, and the states have none. In effect, the state's motion asks the court to presume that the department will act wrongfully and to grant relief on that basis, but the court is actually required by law to presume the contrary. And even if the court were to reverse this presumption the state's motion asks it to do, the court cannot conclude in the absence of evidence that each and every grant termination the department will issue will be unlawful and must be enjoined across the board. The states provide no basis for the court to determine which of the grant terminations will be unlawful because the precise grounds for any termination is a complete unknown at this point. Because the court is without jurisdiction to enjoin the grant terminations, and because in the event the states have provided no evidence to support the allegations made in their motion, the TRO application should be denied. I'll submit on that basis.
All right, thank you, Mr. Kipnis. Ms. Range, any follow-up?
Yes, Your Honor.
I did just want to provide Your Honor with the site for the Thakur because they were citing to the 2025 decision by the Ninth Circuit, but the injunction language is at 787 F sub 3D at page 1005. And you can see what the order language is there. And if you compare it to the order that we request of this court, you can see that they're easily distinguishable. Defendants say that we haven't presented evidence of this plan. Well, our evidence are their own statements that they've made. They have sought approval of a plan, and this plan, they themselves, in their reply in support of the clarification motion, they say, defendant's request plainly involves a concrete situation. The department has informed the court that it is planning to terminate some or all of the grants that are affected by its injunction pursuant to the termination regulation on or after July 31st. There is nothing abstract about the circumstances.
So
And the evidence.
let me just pause you there. What do you, what's your response then to the government's argument that they said, hey, look, we gave you a heads up in good faith about this. We wanted to make sure it didn't violate the injunction. But that doesn't mean it's final agency action. I mean, can those two things be true at once?
No, Your Honor, because under Ninth Circuit holding, under, one moment, Prutehi Litikayan, a plan suffices. And that can be contingent on these later individualized decisions that Mr. Kipnis described. But that plan, once it's in place, is challengeable final agency action. And in our briefing, we provided other examples of plan termination freezes or termination plans that were considered final agency action. And the cases that we cited for that, Your Honor, was Illinois versus Vogt and California versus Wright. Both of those cases involved plans that were set in place that would involve future terminations, but those terminations had not happened yet, so the district court retained jurisdiction. Grantees, as the Supreme Court said in U.S. Army Corps of Engineers, grantees do not need to wait for the hammer to fall on them before seeking relief in district court. As far as what evidence we have of this illegality, we do have evidence that they're going to violate these GEPA procedural protections, and that's because in their own briefing they say grantees will continue to have funding available until the department issues a notice of termination. Well, that's not following GEPA procedural protections. GEPA procedural protections require that you get notice in a hearing before the termination is effected, and that again is made clear in 34 CFR 75-903 subsection C. And they've also told, grantees, as we mentioned before, that they would have to contest these grant terminations in the Court of Federal Claims. That again is depriving them of GEPA procedural protections. And in their briefing on appeal, again and again, they say they have this plan to terminate some or all of the grants. So we're just using their own language, Your Honor, and under binding Ninth Circuit precedent, a plan, once it's in place, is a challengeable final agency action. In regards to this representation made by Mr. Kipnis that the department will not terminate before July 31st, I think we also heard him say, though I could be mistaken, that the terminations could happen before Friday. And so we would just ask, it should be no problem for the government if they are not intending to do stipulations before, or terminations before July 31st, to enter a stipulation and to that effect, Your Honor.
Well, I heard Mr. Kipnis to say that the government was agreeing that no terminations would happen before the 31st. I think he made a very forceful representation to that effect.
Yes, Your Honor, and I heard that as well, and I think we just may have heard him say something different later on, but if we misheard, then we can set that aside. Nonetheless, it should be no problem for the government to enter a stipulation saying that they're not going to do that. And I think, Your Honor, that is all. So I will conclude unless you have any additional questions, Your Honor.
Can you provide any more context to these administrative hearings that are cited in your motion with respect to the department's administrative law judges and those decisions?
Yes, Your Honor. I mean, those are grant terminations that were contested before the Office of Administrative Law Judges under 20 USC 1234D. And that's concerning to us because when they say, oh, well, if we terminate your grants, you're going to have to go to the Court of Federal Claims. Well, there's this whole structure that Congress set up for grantees to be able to go to administrative law judges and have and to contest withholdings, which those administrative law judges held were that withholdings under the 1234D were terminations. And so because of that, it does seem when they say, oh, you have to go to the Court of Federal Claims, that they seek to deprive our grantees of those procedural protections, Your Honor.
And so are these, the decisions referenced there, is that the same procedural mechanism that plaintiffs are seeking to invoke here?
No, Your Honor, because those are for when grant terminations happen. And those courts are not Article 3, they cannot provide equitable relief. We're coming in ahead of the game, right? So we're here trying to stop that from happening. And we do think that based on what they've articulated with regards to the Washington plan, what they've articulated is illegal because they are planning on terminating effective immediately. They are planning on saying you have to go to the Court of Federal Claims, and that's not what the law says. Congress has set up an entirely different framework, I think because they view grants as something different from contracts. Under GEPA, there's a distinction drawn. You have grants, and then contracts are treated separately, and it's clearly laid out in GEPA that is the case. And because there's this different framework that applies, lo and behold, when your grants are terminated, you have a different avenue where you can contest those terminations.
Is the difference between contracts and grants under GEPA, is that something that has, to your knowledge, been litigated in this post-NIH world?
I am unsure about that, Your Honor. I'm unsure about that.
All right, thank you.
Thank you. So in conclusion, Your Honor, sorry, one moment, let me.
Ms. Range, before you wrap up, I do have another question. Are you aware of any mechanism under which the department could lawfully terminate a grant effective immediately?
It would, so you're saying, I think what that would be is for non-GEPA grants. So when you look at the, what is defined as an applicable program under 1234I subsection 2, it carves out grants that were authorized under the Higher Education Act. That's not our grants. So we are considered GEPA grants. But for grants that are not GEPA grants, then there is the regulatory framework for terminations that is the only thing that was cited in that February directive when they were citing to 2 CFR 200-340 and the regulations that follow. Those are the regulations that allow for termination to be effective upon notice. And you can see that as well in the Department of Education's own regulations. When you look at 3475-903, what that regulation says is it's the later of three things. And so it can be for notice, the effective date of a termination can be the date of the termination notice. But it's the date that a final decision is reached if GEPA procedures apply. So what I read when I read that, along with the termination regulation that they've incorporated into their guidance under the uniform guidance that the Department of Education adopted, that when GEPA does not apply, then yes, you can terminate effective immediately. But when GEPA does apply, you have to run through the GEPA procedural administrative process before you can have an effective termination.
Is there any question in the plaintiff's mind as to whether GEPA applies to these grants? I thought that was undisputed, but in my colloquy with Mr. Kipnis, it sounded like maybe it was disputed.
It is no doubt, because if you look at the plain meaning of what is defined as an applicable program. And it sets forth a definition under 20 USC 1234 subsection I, or I subsection 2. It is clear that we are considered GEPA grants, and there's also citation in the docket where when the grants were issued, it said these are GEPA grants and GEPA procedural protections. They would cite to Title 81 of 34 CFR, and those are the GEPA administrative regulations. So yes, I think there's no doubt that these would be considered GEPA grants. And we also, in our motion for a temporary restraining order, we kind of walk through that analysis where we go through the definition, and then we also point out the authorizing statute for our grants is not the Higher Education Act, so then therefore, under the statutory definition, we're considered a GEPA grant.
All right, thank you, I appreciate that.
Yep, thank you, Your Honor. So in conclusion, the court should clarify that defendants cannot use unpublished priorities to terminate protected grants and grant plaintiffs' motion for a temporary restraining order enjoining defendants from implementing or enforcing through any means the February directive, the June directive, or the Washington plan, or any other materially similar policy against protected grants. Thank you, Your Honor.
All right, thank you, counsel. The court will take the motions, both motions, under advisement, but will issue a decision as soon as possible. I do understand and appreciate the urgency on both sides, both the government's request for clarification and plaintiff's request for a temporary restraining order. And I appreciate the parties' briefing and argument and the expediency with which we were able all to gather here today on a shortened schedule. So thank you for that. This is an important case, and I will issue an opinion as soon as I can. So thank you. We'll be in recess.
All